Hello everyone, this is Aboorva, a legal intern under LEXIQ law firm. Today I have created three illustrations on labor laws and which I've tried to answer them with the relevant provisions, acts and case laws. So let's move on to our first illustration. A company involved in manufacturing of products like electronics, a salesman of the company supplies the products outside and collects the money from them. The salesman during the employment met with an accident and passed away. So here arises a question whether the salesman can be considered as a workman of the company, and whether the persons dependent on the salesman can get compensation under Employees Compensation Act. For the relevance of this question, I would like to this illustration. I would like to mention a case law which is held by Madras High Court. The case is Holy Faith International Private Chennai versus Presiding Officer. It was held in this case that an employee who is designated as sales representative but discharging duties of clerical and manual nature will be a workman under Industrial Disputes Act. So, as per Industrial Disputes Act, the workman is defined as workman means any person employed in any industry to do manual, unskilled, skilled, technical operation, clerical, or any supervisory work. So, in the light of this judgment, it was made very clear that the salesperson is also considered as the workman of the company. As for the compensation, according to Section 3 of the Employees Compensation Act, the employee died during the course of the employment. So the employer is liable for compensation of amount 50% of the monthly wages of the deceased employee, and it is multiplied by relevant factor or an amount of 1,20,000, whichever is more. So the employer is liable to pay whichever is more to the employee, so to the deceased employee's dependents. So let's move on to our second illustration. Chirag, age 14, is working in a lab. It is a registered factory. He was asked to work for more than 7 hours without any interval, and when he was unable to complete the work, he was forced to work between 10 p.m. and 7 a.m. to complete the work. And he was not allowed to have weekly holiday as well. So, what is the liability of the employer in this case? In this case, the employer who made the child employee work overtime and without interval and without weekly holiday. As per Section 7, Clause 4 and Clause 5 of the Child Labor Prevention and Regulation Act, the total number of working hours of a child employee should not exceed more than 6 hours. And this 6 hours also should include 1 hour of interval. Mm, So, according to the Act, the employee cannot make a child employee work between 7 p.m. and 8 a.m., and no employee must permit the child employee to work overtime. Also, the employer makes the 14 years old employee to work without weekly holidays. Uh, uh, for this, the Section 8 of the Child Labor Prevention and Regulation Act is applicable, because Section 8 of the Child Labor Prevention and Regulation uh, Act states that every child employed in an establishment shall be allowed in each week a holiday of one whole day, which day shall be specified, which the holiday has to be specified by the employer in a permanent notice, and it cannot be changed more than once in 3 months. So therefore, this act of the employer contravenes the sections of this provision. So, uh, the employer is liable for simple imprisonment, which may extend to 1 year, or fine, which may extend to 10,000, or with both. So let's move on to our third illustration. X, an employee with more than 7 years of service, was dismissed because of disobedience. The company, on account of festival, paid bonus to all employees except X, whether X can challenge this in the court of law. So the employee was dismissed on grounds of disobedience. Uh, can he is he entitled to bonus? Yes, he is entitled to bonus, and he can challenge this in the court of law. Uh, because according to the given illustration, he is dismissed on the grounds of disobedience, but in the section 7 of the payment of bonus act, which deals with the grounds for disqualification of bonus, and provides that an employee who is dismissed from service for fraud, riotous or violent behavior, theft, misappropriation or sabotage shall be disqualified from receiving the bonus. But in the given case, the question of disqualification was not from any of these grounds. It was only from the disobedience. So he is entitled for bonus. The employee is entitled for a bonus. The workman would therefore be entitled to prefer an application under section 33 subclause C, subclause 2 of the Industrial Dispute Act 1947, if he is deprived of the bonus amount by the employer. For recovering the same, also as per section 10 of the Payment of Bonus Act 1965, every employer is bound to pay every employee a minimum bonus with which can be 8.33 percentage of the salary earned by the employee. Therefore, as per the facts, the payment of bonus is a statutory obligation of every employment. Judgment. The same judgment was given in a case, Gujarat High Court by the Gujarat High Court in the case of Union of India versus Kishore Laka in 2003. So, if you have liked my video, please subscribe to this channel so that you can be updated with our new videos. And if you also have any alternative answers for these questions, you can drop them in the comment box. Or if you want to answer any question, you can drop them in the comment box as well. Thank you.